Welcome to our channel. Today I will be discussing with you whether you should incorporate your new business in the state of Delaware. First, a little bit about our law firm and myself. We are a New York and California business and intellectual property law firm. And I am a corporate lawyer, and I am licensed to practice in the state of New York. So, first off, what does it mean that a corporation is incorporated in the state of Delaware? In the United States, there's no uniform federal statute for business legal entities. Individuals who wish to set up a new business venture to form new business legal entities, whether it's a corporation or limited liability company or limited partnership or limited liability partnership, could, to some extent, shop the forum among different states. So if a corporation is incorporated under Delaware law, or if a limited liability company is formed under Delaware law, it means that the general corporation law of the state of Delaware should govern the corporation's internal matter. And the Limited Liability Company Act of the state of Delaware should govern the internal matter, the corporate governance matter of the limited liability company. So what are the internal corporate governance matters? They are things like the rights and obligations of shareholders versus the company and each other. The rights and obligations and responsibilities and authorities of board of directors and the members of the office, executives, right, versus each other and the board and the shareholders. Those are the corporate governance issues, matters. But such a Delaware corporation or limited liability company can still be headquartered or operate elsewhere, for example, in the state of New Jersey or New York. And the business will be subject to the labor law and income tax laws, generally speaking, where it operates its actual business. And it could be several jurisdictions, right? But so you would ask why so many businesses, including about half of Fortune 500 companies, are incorporated in Delaware. Those are a few reasons. First, there's a rich body of well-developed case law regarding corporate governance in the state of Delaware. So that if there are any kind of disputes or uncertainty, you can go to the case laws and hopefully find a good body of law and as your guidance and starting point, at least. Also, the Delaware Court of Chancery specializes in corporate issues, and that court uses specialized judges who almost exclusively adjudicate on corporate governance matters. So you can expect a lot of experience, competency, and speed, relatively speaking, from there. Also, Delaware offers more flexibility than a lot of other jurisdictions in structuring and governing the entity, which we will not have time to go into. For example, just one simple example, a Delaware corporation could survive with only one director sitting on the board of directors. In California, once you have a certain number of shareholders, then it has to be more than one member of the board of directors. And Delaware does not require corporations to disclose the identities of its shareholders, and that's very important for a lot of investors. And this kind of critical mass of Delaware corporations kind of become a force of its own. So you have New York lawyers like me who spend 98% of his time drafting Delaware corporate governance documents instead of New York corporate governance documents. And then you have a bar of corporate governance litigators, well trained, well versed in corporate law in the state of Delaware. And then you have private equity firms whose lawyers, like me, work on Delaware corporate laws. And therefore, venture capital investors and PE investors, they prefer to work with corporations that are incorporated in the state of Delaware because they are familiar with the lawyers and the law there. So taxes are not really the reason behind this. For corporate income tax, right? Most states, tax the actual economic transactions that occur there. So if you are a Delaware corporation, but you derive most of your incomes and conduct most of your activities in the state of New York, at least to that extent, that income is subject to New York tax. And as for the shareholders, if you receive capital gain or dividend, right, you report income tax to the state where you live. I hope that's true for most states. But this is not a one side or one state fits all situation. For example, if you have a very simple structure like one shareholder, very simple, your governance is between you and yourself. And if you are in Georgia, why bother to incorporate a venture in the state of Delaware? You have to do 2 filings then. If you watch my other video about how to set up a new business legal entity, you have to get foreign qualification for the Delaware corporation to do business in the state of Georgia, right? And you also may have to travel to the state of Delaware if you have to litigate. And even if you have more than one shareholder, sometimes if you have the shareholders contribute very homogeneous things of value to the corporation, whether it's service or capital, right? If you have 3 shareholders contributing equal amount of capital to buy real estate and hold in long term, you would just get 1/3 of the cost and get 1/3 of the benefit. And there are a few matters that will require your lawyer to help you figure out, such as what kind of vote would you need to make certain decisions, right? So simple majority and all that. I'm sure other jurisdictions would have a body of law to take care of that as well. So this is today's topic. If you like our channel, you're welcome to subscribe it. Thanks again for your time.